Can I have a motion tomorrow, my what matter? Well, it's a matter of appointment, my lord. I was forward for appointment. In the meantime, my lord, advertisement is issued, and they are going to declare the result, my lord. So one post may be reserved on the that. I'm of that.
For listing matter under usual column.
Item number 39, my lord. I want to withdraw the miss case number 3476 of 20. Item number 39. I want to withdraw the
Mr.
Miss
S.K.
case.
Pandit, learned counsel for the applicant.
3476
Item
of
3476
2020.
submits that he has instructions to withdraw this IA. The prayer is not opposed by the learned government advocate Assam. In view of the above, these IS can disposed of on withdrawal. Yes.
May it please your lordship, I'd like to mention item number 31. I've taken consent from the other side. Here we have to file a rejoinder to the affidavit in opposition filed by them. May I pray that the matter may be listed after 3 weeks, your lordship.
On the prayer of Mr. D. Bawal, learned counsel for the petitioner made with the consent of the other side. This matter still sent for 3 weeks, so as to enable him to file.
Interim order may continue.
Rejoinder affidavit, interim order for to continue. After 3 weeks.
Highly obliged.
My lord, I wish to mention for listing tomorrow, my lord. My lord, my lord, recommendation for residential accommodation. For our group A officers. My lord, similar matter, my lord, already, my lord, they passed this honorable code on 6 on 27, my lord,
27.
April.
Then you have it on 27.
Which is,
Get it listed on 19th. We'll pass an order for 27th. 27th, other matters are fixed.
other matter,
You have it, mention the date of 19th. On that day, we'll pass an order fixing it on that.
then was 27, my lord.
Yes.
May I please, my lord, for listing my lord on 19, my lord,
What matter?
regarding appointment of compassionate ground.
You make a mention on 19th.
Lordship,
17 my lord is pending, my lord.
Yeah, you make a mention on 19th.
Lordship, I beg to mention a matter for listing it on tomorrow, Lordship. The urgency is that the departmental proceeding was initiated, that got concluded. Now, without opening the seal cover, they proceeded with the DPC, Lordship. On 6th, Lordship. If one post is not vacant, there will be no accommodation from Lordship tomorrow.
No, why tomorrow?
Lordship, they will proceed, they will finalize the,
We'll set it aside. If
No,
they
Lord.
don't do it as per the norm, then we'll set it aside.
Lordship, on 6th they proceeded without opening the seal cover.
That's
Lordship.
correct. You have it on 19th. Yes, next matter, please.
My lord,
19th.
order number 18, my lord, my kindly be adjourned for the day only, my lord.
Item 18 on the prayer of learned counsel for the petitioner, this matter stands adjourned for the day. Yes.
May I please your lordship, I beg to mention for listing on tomorrow, my lord, matter relating to appointment, my lord. Post held by me, someone is appointed by motion,
For motion,
for motion, my lord.
why you cannot wait till 19th?
Lordship, it is a matter of appointment, my lord.
19th, yes, next matter, please, 19th.
May I please,
Lordship,
lord.
post held by me is someone appointed, my lord.
We will,
I will be served.
we'll interfere if it happens.
He will join, my lord.
Rejected, yes.
May I please, lord. My lord, I wish to mention item number 28, my lord.
Hmm.
Let me kindly withdraw, my lord.
28.
My lord.
On the prayer of Mr. B. Islam, learned counsel for the petitioner, this matter stands disposed of on withdrawal. The learned standing counsel PHU of Assam is present. Interim order, if any, shall stand vacated. Yes.
Lords, we would like to mention item number 2, my lords, the counsel for the petitioner is very unwell, my lord. He's not in Guwahati, he's in Calcutta.
As paid for by learned counsel.
Maybe adjourned.
This matter stands adjourned for a week. List accordingly. Yes. sir.
Grateful.
May it pleases your lordship, lordship, I beg to mention item number 33.
What do you want?
Lordship, the conducting council is out of station, your lordship.
You are for the petitioner.
Yes, your lordship.
As paid for by learned counsel for the petitioner, this matter stands adjourned
Lordship, after vacation.
for a week. Yes. List accordingly. Yes.
Right, please, your lordship. I beg to mention item 37, my lord, with the consent of the other party. In this, I have to file the rejoinder, my lord. 3 weeks time maybe. That party,
You have filed or you want to file?
I want to file rejoinder. Item
Nah.
37.
No, I'm appearing for respondent number 4 in this case.
Mr.
V.K. Chopra.
V.K. Chopra, learned counsel for the petitioner, applicant, raised for. Learned counsel for the applicant raised for, and 3 weeks time to file rejoinder. If the prayer is made with the consent of the other side, same stands allowed. Miss
And Rahman.
N. Rahman, and counsel is present on behalf as per number 4.
I'm appealing for 1 to 3 year.
And Mr.
R. Paul.
R. Paul, correspond numbers, one, two, three. Put it serial number. Yes.
May it pleases your lordship, I beg to mention item number 8 of the daily list, lordship. Kindly adjourn the matter for the day, lordship.
As paid for by learned counsel for the petitioner, this matter is passed over to the day. Yes.
May it please your lordship, I beg to mention 2 items for listing after the petition, lordship.
Listing for what?
Lordship, lordship, the
Listing
matter
for what?
for admission, lordship.
First week of May. What I did. Yes.
And lordship, item number 22 may be adjourned for the day, lordship. The
22.
against
You are for
counsel
whom?
is not well.
You are for whom?
For petitioner, lordship.
You have informed the other side. With the consent of the opposite party, the petitioner's counsel placed for adjournment in this case for some prayer allowed list accordingly.
Thank you.
Please, your lordship, mention one item for listing for tomorrow, lordship. This meter pertains to appointment of governor, and in this case, lordship, I have challenged the selection procedure, lordship. And in the meantime, also I had the apprehension that during the vacation, lordship, the respondent number 7 may be appointed, lordship. So,
File an appeal. These are all matters. You file an appeal. You filed an appeal.
no, lordship,
You file
this
an
is
appeal.
pending, lordship.
File an appeal.
There may be a direction, lordship.
No,
on
you
this.
file an appeal.
No, lordship,
You can file an appeal on 19th. On 19th also we can pass that order.
lordship,
What is
lordship, lordship,
You wait till 19th.
lordship.
My lord, item number 23, 26, and 27, my lord. Here, my lord, pleadings are otherwise complete. Today, my lord, there might be some constraint, my lord, as the CBSEs are also saying, my lord. Can it be after, my lord, sometime in May, my lord? 23, 26, and
23,
27.
26, 27, learned counsel for both the sides have submitted that these matters are ready as we got ready. And therefore be taken up for admission hearing on a non-miscellaneous day after the, in the first week of May 2026. Prayer allowed, we used to meet these cases accordingly.
Deep level. My lord, 43 to 47, my lord, we beg to withdraw, my lord. 46, 47, they have become infructuous. And 43, 44, and 45, my lord, the petitioners are not willing to pursue, my lord.
46 and 47 have become infractions.
Infructuous, my lord.
Mr. B. Pathak, learned counsel for the petitioners. In these cases submits that these matters have become infructuous by efflux of time and therefore be disposed of. First of Ms. A. Gayan Lanet CGC is present on behalf of the respondent. In view of the prayer made by the petitioners council, both these writ petitions are hereby disposed of as infructuous. And in 43, 44.
44 and 45.
You submit that Mr. B. Pathak, you write Mr. B. Pathak, Lanet counsel for the writ petitioner. In these writ petitions submits that he has instructions from his clients not to press these writ petitions. As such, these matters be closed as not pressed. Ms. A. Guy, who is appearing?
Lordship,
Mr.
in
S.S. Roy?
43 and 45, I am appearing, Lordship.
Mr. S.S. Roy, Lanet, Mr. S.S. Roy and Mr. K.K.
I am
Parakh,
for 44.
Lanet counsel appearing for the respondents in these matters do not have any objection if the prayer is allowed. In view of the above, these writ petitions are disposed of as not pressed.
Obliged.
Deep level.
Yes, what is 48? You want to withdraw?
No, yes, Lord. Liberty may be granted.
Sorry,
Liberty may be granted, Lord.
why you want to withdraw?
Because there are some necessary parties to be implemented, Lordship. That is why, Lordship.
Mr. A. Dekal and counsel petitioner commits that there is some defect in constitution of the writ petition and therefore the petitioner be permitted to withdraw this writ petition with liberty to file afresh. The prayer is not opposed by Ms. M. D. Bora, Planet Government Advocate Assam appearing for the state. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for.
Deep level.
Not big lordship. My lord, the petitioner before your lordship is a registered trade union. All of its members are the drivers, handymen of the defined vehicle.
Yes.
Drivers, handymen of defined vehicle used by Oil India Limited. My lord. Now, what happened in the year 2014, a settlement was arrived at. By this settlement, the wages were fixed. However, so far the Provident Fund benefits are concerned, that will be disbursed by the Oil India Authority. The next subsequently in the year 2017, Lord, that is Annexure B, 2017, another settlement was arrived at. By this settlement, a job security, they call it job security settlement. Your lordship will find at page 37, my lord. No. Clause 1, Lord. Regarding the engagement of drivers and helpers, contractors, owners have the right to select the drivers, helpers. However, preference will be given to the earlier driver and helper by the contractors considering their past record. Now, my lord, subsequently, my lord, one writ petition was filed by, and that writ petition, your lordship passed an order, and that had created problem, Lord. Yes, the same way your lordship's order is that at page 40.
Page 42.
Page 40. Relevant page is page 42.
Yes.
However, taking note of the nature of the grievances expressed in this situation by way of the identity measure, it is provided that petitioner be permitted to drive their own vehicle if so desired, subject to their possessing the. Now, Lord, this order has been constituted that you cannot now insist for any job security settlement.
So what is your prayer here?
Now, Lord, we are insisting for our job security settlement, but they are not implementing it. On several occasions, we approved before them, and Lord, I have all those orders are there. All several occasions we approved before them. The plea of the Oil India is that the matter is subjected before this Honorable Guwahati High Court, so we cannot talk about this.
So your clients want a job security certificate.
Yes.
What is the prayer in the petition?
Now, Lord, when we insisted for the job security, they have not declined to give it. Then we resorted strike, and in that strike, Lord, they have imposed the penalty and liquidated damage, a huge amount of penalty and liquidated damage. And we approved before this Honorable Court against that penalty and liquidated damage, Lord. So only thing is,
My pleasure. Lordship, the liquidated damages was already recovered in the year 2021.
yes,
Now we are in the 2023, and apparently the averments in the petition shows that we have recovered from the contractor, not from the union, Lordship. So they have to make the contractor as a party respondent, Lordship. And apart from that, Lordship, already memo of settlement was arrived on 22 July 2022 between the petitioner union, contractor, as well as the Oil India as a witness, Lordship. All the dispute was, they have already agreed that all the parties involved also agreed that the unions or the members of the union benefiting from the settlement would withdraw any dispute, litigation pending in any legal forum raised by them of the or their members. This is a conciliatory settlement, Lordship. It is binding under section 18, Lordship.
no, so far
I am
this
also
job settlement is
giving a copy, Lordship.
right, no, I have the copy.
So
So far this job settlement is concerned, they are declining to discuss this matter only because there is a pendency in that.
Mr. Dasgupta, your basic grievance is not providing job security.
Yes.
Where is the prayer in the petition?
No, so far in this situation, there is no prayer. In this situation, when we have insisted for the job security, they have declined to give that because on taking the plea, the pendency of the writ application, so we had to resort strike. And as the strike was resorted, say they imposed penalty and liquidated damage.
So he's saying the penalty has already been recovered from the
Yes,
contractor.
Yes, that was one.
recovered from the contractor, Lordship. Their averments of the petition also they have.
No, I have.
They,
Let him finish.
The contractor has recovered it from all the drivers and crew personnel. I have annexed the document. Now, Lord, my plea before your lordship, that if your lordship go to paragraph 29 of my writ application.
Yes.
You cannot. I have quoted two sections of the Trade Union Act.
So Mr. Dasgupta, the recovery has been made from the contractor.
Granted. No. Recovery has been made from the contractor and contractor has realized this amount from us. And we have annexed that document.
But
Yeah.
is the contractor a party here?
No, contractors are not party, but these recovery, they have realized this recovery, this amount from us. Because
Is the
of this.
contractor a party in this writ petition?
No, contractor is not party in the repetition. So far the liquidated damage is concerned, this damage was imposed because the crew personnel has gone for a strike. And these, as the crew personnel are the employees of these contractors, say they imposed liquidated damage. And the contractors, they have recovered that liquidated damage from the salary to be paid to us. That is the case before you left in nutshell. Now, Millard, so far the imposing of the penalty and the liquidated damage is concerned, Millard, that is barred by section 18 and 19 of the Trade Union Act, when a registered trade union reserved for a strike. That I have pleaded here and I have also quoted that sections. Just that section, Millard. So, Millard, should I read it?
Mr. Dasgupta, there is a problem here. You can rectify it or you see, the Oil India has made a recovery from the contractor, not from the trade union members. The contractor has deducted the amount from your salary bills, right? So basically your grievance is against the contractor, who is not even a party here.
No, basically my grievance is the impugn order. That impugn order is at page 87. And all these things are outcome of that impugn order. And in this impugn order, they specifically stated what had happened.
So you don't think contractor is a party?
No, I don't think so. So for the impugn, I am agreed by that impugn order. And if this impugn order is quashed, then nothing will survive. And so far this impugn order is concerned, it specifically states that the liquidated damage has been imposed on the trade union workers who resorted for strike. So my contention, one of the contention before your lordships, even if we assume that you went for a strike, then also you cannot impose liquidated damage. Because of the
Correct,
provision.
but now it has already been done.
That is already that is done, and my prayer is that it should be recovered. It should be refunded.
Then we'll issue notice.
And if your lordship made, all that your lordship made, at this
But,
stage, at this stage,
But without the contractor, I don't know how this matter can be ultimately decided. Without the contractor, I have my doubts.
No, I have specifically,
Because they will come and say that we have not made any recovery against your client.
No, I am not. Impugn order is dated page, if your lordship goes to page 87, Millard, everything will be clear.
All right.
87, just as a short order.
Yes. Page 87. Yes, please.
This is, let us skip up first paragraph. Now, it is important. This is to inform your kind information the Motor Workers Union, who is the registered trade union before your petitioner before your lordship, had organized a strike during the period 16 to 2021 to 22 2021 regarding their demands of written assurance from their from Oil India Limited for their job security. The strike resulted in non-cooperation to carry out any activity by the Motor Workers Union drivers. In order to ease to pressure created due to non-cooperation of Motor Workers Union drivers of hired vehicle services, the company owned vehicles, certain number of owner-driven hired vehicles, non-members MIU, were mobilized to meet their basic operational requirements. The major drilling productions and the workership changes could be done through these limited resources. However, there were considerable production losses incurred due to the non-availability of the hired browsers due to the strike. We would like to state that due to the adamant and aggressive attitude by a section of the drivers of hired crude oil browsers, the strike could not be withdrawn at the earlier date as per the confidential information received by us. It is to be mentioned here that after prolonged discussion with Motor Workers Union and involvement of Oil India Limited management as well as the district administration, the strike was formally withdrawn on 22/2021. During the discussion and as per the withdrawal letter of strike of MWU, that is Motor Workers Union, proposed of no work, no pay. That was our proposal against the non-availability of the service. However, it is intimated to them that the matter would be discussed in proper forum. Considering the unavailability of the service and as per the clauses in respective contracts, it is proposed to impose penalty for the period of unavailability of service on the contracts in the LMC meeting dated such and such 1/3/2021. However, it has been noticed that though the contracts of all categories of vehicles, including similar clauses of imposing penalty, both liquidated damage penalty, both liquidated damage and the special liquidated damage, the contracts pending to the browser services under OGPS do not include the same clause imposing SLD. It may be mentioned that the Motor Workers Union had earlier submitted a prior intimation before carrying out the strike. As such, it may not be justified to consider the same as a flash unauthorized strike against which SLD can be imposed. Moreover, imposition of SLD might cause financial burden on the contractor and the means. It is to be further noted that impact of the strike was more in terms of the loss of production due to non-availability of browsers compared to other categories of vehicle. But the recovery of penalty will be much higher case of the higher trailer for flat tracks, etc. Imposed all have higher vehicle except the browser. Therefore, looking to the same default as quoted below through two different respective imposition of liquidated penalty would not be pragmatic, should be considered under same level, the paying field level.
We'll issue notice ultimately.
But that is, yes.
All right.
Yeah. Apart from that, I can pray
But we stay at
because
the
it has already been
petitioner
recovered.
counsel listed by Ms. Bida as counsel for the petitioner. Also had Mr. M. Kalita, counsel appearing for the respondent numbers 1 and 2. And Mr. T.C. Chutial and Government Advocate Assembly, additional Government Advocate Assembly appearing for the respondent number 3. Notification dated 5/3/2021 issued by the Oil India Limited, whereby penalty in the form of liquidated damage and or special liquidated damage has been imposed upon the striking drivers of the vehicles. The instant writ petition has been filed inter alia contending that the impugn notification is hit by section 18 of the Trade Union Act. Full stop. Mr. Kalita, on the other hand, submits that the action has been taken due to contravention of a settlement agreement by and between the parties, and therefore the same does not call for, therefore the impugn notification does not call for any interference from this court. First of the issues raised in the writ petition would call for deeper examination. First of NOM 6 weeks, since the parties are already represented, no.
Respondent number 3, I cannot appear, it is central government.
So you cannot appear.
No.
And if there is CGC here, then you be Chakravarti instead of. Since the parties are no formal notice, extra copies. The respondents to bring their stand on record by filing affidavit before the returnable date. But you should implead the contractor, otherwise there will be unnecessary technical issues.
Let me check it up.
Check it up, what is.
Because if the contractor, there are thousands of contractors are there.
Correct.
3,000 vehicles are playing. So if I have to break, they are interested to get the. So I have to break all the 1,000 contractors.
All right, we'll see that.
I will, if equal, I shall give the feelings. You know, if
At
there
least
have been only one contractor, they have
In representative capacity, you can.
Agreed, boss.
My lord, in this case, my lord, as per order of this honorable court lordship, my lord, the petitioner appeared in the interview lordship, he was allowed to appear in the interview lordship. And the finally, my lord, in the written test, my lord, successfully completed lordship, but the kindly see page 47 lordship. My result was not declared, my lord. A message was sent to my mobile lordship. Disqualified because of submission of fake certificate without, my lord, any inquiry, without any hearing lordship, without mentioning any document.
So let him file affidavit. Then only-
We have filed an affidavit, my lord. Only one instruction is necessary, my lord. A committee is, my lord, constituted for scrutinize all these things. And a series of cases also pending, my lord, regarding this fact certificate. But I will obtain instruction. What is his fact? His computer certificate is fact certificate. How it is fact, my lord, I will obtain instruction. Only that point only. Which otherwise is not eligible, my lord.
Then we'll issue notice and fix it. for-
Yes, motion is notice may issue, my lord.
Heard Mr. M.A. Ahmed, Learned Counsel, query for the petitioner. Mr. Ahmed submits that although his client had duly participated in the recruitment process and had fared well, already fared well, yet his candidature has been rejected on the alleged ground of submitting fake certificate, although no such particulars have been furnished to the petitioner till today. First up, is the chief TCTPL and an additional senior government advocate Assam appearing for the state submit that although an affidavit has been filed in this case on behalf of respondent number 2, yet he be granted 3 weeks further time to seek instruction as to the nature of fake certificate submitted by the petitioner. First up, since the aforesaid aspect of the matter would have a crucial bearing in the outcome of the petition, I am inclined to grant time to the Learned Government Advocate Assam as paid for. Issue notice of motion returnable on 12th of May 2023. Since Mr. Chetia has appeared and accepted notice for all the respondents, no formal notice is required to be sent. List this case for admission hearing as a fixed item on 5/2023. On or before the next date fixed, the Learned Departmental Council to produce the records pertaining to the allegation made against the petitioner.
In the meantime, lordship, a post may be directed.
No,
to
there
the
has already been, my lord,
second
fill up. No, my lord. This case has been, my lord.
See, if there is nothing, then they will have to accommodate you.
lordship. All like this.
In this case, we have filed an affidavit, my lord.
May I please, your lordship? We have not yet received the copy of the affidavit.
Affidavit.
We have not yet received the copy of the affidavit, your lordship.
I will provide it, my lord.
Lordship, I have a.
Yeah.
I have a prayer, your lordship. For the brief of the case, your lordship, the petitioner applied for, after seeing an advertisement for the appointment of the Anganwadi worker for number 2 Dokuapara Anganwadi Center, which was vacant since past 7 years, your lordship. And advertisement was made on 11th January 2020. And she underwent the interview on February 20, 2021, and a selection list came out. That is on page number 22, your lordship, and 5, your lordship, where she have secured the first position, your lordship. Kindly come to 8 point, your lordship. Dokuapara number 2, Anamika Patwari first. Page number 22, your lordship, annex number 5. After that, your lordship, why she was not appointed and other people whose name were reflected in the selection list were appointed. And then she made an inquiry, personal inquiry, and she was not answered by the respected department why her appointment was kept in pending. And later on, your honor, your lordship, we came to the court
for seeking the answer, and then your lordship, they took time from us to, nice, they took time from the honorable court to file their affidavit. And but in the meantime, your lordship, they have appointed another person in the same post, your lordship. So without assigning us any a reason for not being appointed in the post over while securing first position after all the scrutinizing my documents, my
Yes,
eligibility and
why have you not appointed her after?
No, my lord, we have filed an affidavit. As per affidavit, my lord, what happened? Petitioner got marks. She got in the higher secondary council, my lord, got 5% gap. Guess mark, my lord. That was cannot be, my lord, counted for the calculation of the percentage. That has been cleared by the council. We have filed an affidavit, lordship. Earlier, yes, she was got 48.40%. She was highest, but subsequently it is scrutinized that she got guess mark 5. That is minus. It is cannot be calculated for percentage of in mainstream, my lord. That's why, my lord, petitioner approval is not given. That is our stand, my lord.
Yeah, where are the records? Selection process record?
That is, my lord, higher secondary, my lord, this selection committee clarified from the, my lord, higher secondary council, my lord.
You take a copy and examine it. We'll
So
have
I
it
will
on
give her, my
file.
lord, a copy of her affidavit, but I don't know without.
and they have not yet served us any copy for the affidavit, your lordship.
But you have to implement the selected candidates. If you succeed, then if it is to be set aside, it cannot be done without implementing. Who is the selected candidate?
Director
Who
of
has been
Social
appointed?
Welfare.
Director has been appointed as Anganwadi worker.
No, your lordship, a different, a person named Sunita Boro, your lordship. As per the news article that came out, your lordship. 2 news articles came out.
Who has been appointed in this post?
I don't know, my lord, that instruction is not with me.
Due to
Acha.
shortage of time, I could not take up the copy, your lordship.
All right, we'll have it on 20th April.
Wait,
Have
wait,
a
wait.
copy then.
I will have a copy, my lord.
Yes. Ms. B. Das, Land Council,
Copy,
is
sir,
submitted
no,
to
filing
petition
will
submit
go.
that she has not received a copy of the affidavit
Copy to this one.
filed by the department. Government administration, Assam is present. He has furnished a copy of the affidavit to Ms. Das today. As such, and on the request of Land Council for the petitioner, this matter is directly posted again on 20th of. Or you
20th.
can make it 21st of.
In
April.
the meanwhile, they will be kindly direct them to serve me a copy, your lordship.
Yes, I will serve. First, I will verify, my lord, without serving copy, we cannot file an affidavit.
So you give her a copy. She-
Give, oh, no, camera, I will provide it. Obliged, my lord.
Your lordship.
With lordship. So in this case, my lord, the petitioner was, my lord, selected and recommended by the district scrutiny committee. My lord, kindly see page 21, lordship, the DLC, my lord, recommendation, my note, lordship. Page 22, the relevant portion, lordship. My lord, 2 candidates were there, lordship, Zahinur, and the petitioner is Zahinur, and my lord, Saleha. The petitioner was recommended, my lord, point number 1, lordship.
Yes.
Now, against the one, my lord, reserved category, he was recommended, lordship. Now, state level committee, lordship, that is kindly be seen at page 32, lordship. Relevant is at page 35, lordship. My lord, serial number 14, kindly be seen page 35.
Yes.
My lord, serial number 14, the remark, lordship, could not be recommended on the basis of financial need, yet 4 candidates were selected on the basis of financial need, prioritizing economically weaker section first, lordship. My lord, as per, my lord, considering everything, financial condition, my lord, among between 2 candidates, I was
So
selected.
who was appointed in that post?
My lord, at the time of filing, nobody was appointed, lordship. Now, my lord, I was not, my lord, considered, my lord, accepted, lordship. Because, my lord, nobody was there, my lord, financially backward, my lord, weaker section, lordship. Now, 2 candidates were there, my lord, one Saleha, my lord, and me, lordship. I was selected, lordship. Then, my lord, as per my lord, official memorandum, my lord, no, my lord, there is no room, my lord, of my lord, for my lord, EWS.
I have
lordship.
received one instruction, Lordship. How the financial economically weaker section has been calculated by the SLC. Lordship, may I kindly have it?
So who has been appointed against this post?
His Lordship, may kindly have a look at the page 33 for a moment. The SLC recommendation, then my senior will explain this matter. The Abhayapuri Mechanical Division, grade 4, Srimati Pratima Roy. If my senior may appraise his honorable court regarding PWD department matter. Page 33, I have seen matter.
Yes, who has been appointed in this post?
Lordship, Lordship, here the recommendation doesn't reflect with regard to the Lordship, Bongaigaon Rural Road Division. It states only about the Abhayapuri Mechanical which comes under Bongaigaon, Lordship.
Then
Division.
how the instruction has been given? There is written instruction given here.
That Lordship.
What has happened? Can you throw some light? Who has been appointed in this case?
Lordship, I will take instruction, Lordship, in that post. Because a DLC recommended only one person, Lordship.
So that person was not,
If as going by the.
DLC recommended the petitioner,
Yes, Lordship,
but he was not
not
appointed.
recommended.
The ground shown is that he does not meet the economic criteria. So therefore, who has been appointed in that post? And what was the consideration for doing so?
Yes, sir.
Give us the record,
I will
file
take
an
that.
affidavit.
Yes,
They have to file an affidavit.
Lordship.
Take down. Heard Mr. M.H. Ahmed Lanik, counsel for the petitioner. The lead petitioner herein had submitted an application for appointment on compassionate grounds. The district level committee of Bongaigaon district had considered the application of the petitioner and another candidate, and thereafter recommended the name of the petitioner for appointment in a grade 4 post after assessing the financial status of both the applicants. The SLC has, however, declined the prayer of the petitioner on the ground that he did not fulfill the financial criteria. Ms. M.D. Boral and Government Advocate Assam has produced a copy of the written instruction dated 8/12/2022, which goes to show that persons who were in a more vulnerable financial condition were considered, whereafter appointments were made. However, there is no indication as to who was appointed against the grade 4 post in question. It is also not clear as to what procedure was followed by the authorities while selecting the final candidate for appointment to the grade 4 post on compassionate ground. Mr. B. Chaudhary, learned standing counsel, PWD Assam, 4 weeks time to obtain instruction and file affidavit placing those facts on record. Prayer allowed, issue notice of motion returnable on, give a date after 4 weeks, returnable on 17th of May 2023. Since Mr. Chaudhary has appeared and accepted notice on behalf of respond numbers
Lordship, 1, 2, and 3.
1, 2, and 3, and Miss M.D. Boran and Government Advocate Assam for respond numbers 3 and 4.
4 and 5.
Service, 4 and 5. There is no 5 here. 3 and 4.
Lordship, numbering it.
4 and 5.
Yeah.
Uh,
we are allowed
No
to
formal
correct.
notice is required to be signed in this case. Extra copy of the registration
On
will furnished to the Learning Department Council so as to enable them to obtain instruction and file affidavit. It is made clear that appointment, if any, made to the grade 4 post in concern on compassionate ground will be subject to the outcome of the repetition.
Obligation. My lord, respondent numbers maybe I may be allowed to correct yours. Obligation.
Item 6.
Make. May please, your lordship. My lord,
Let's say waiting for instructions, so need more time.
my lord, it's a long time, my lord, since my lord, my lord, they are asked, my lord, notice has not been issued, my lord. Notice may be issued. my
Will
lord.
issue notice.
Yes, my lord. Otherwise,
Mr. G. Goswami, learned counsel for the petitioner, perused the amendments made in the writ petition. Ms. N. Bora, Lana, standing counsel, PNRD Assam, submits that instructions as called for has not yet been received. As such, 3 weeks further time be granted. In view of the above, issue notice of motion returnable in 3 weeks. Since Ms. Bora has appeared and accepted notice on behalf of all
All
the
respondents.
no formal notice is required to be sent in this case. Extra copy will be written will be furnished to the Learning Department.
Please.
Item 7.
So as to enable her to obtain instruction.
Lordship, this matter pertains to compassionate appointment, your lordship.
Hmm.
This is the third round of litigation. Impugn order is at page number 90, your lordship, relevant person,
90.
90, your lordship. 81 your type copy that will be perused. Page number 81, your lordship, annexure 16.
Hmm.
It is because of delay, your lordship, it has been rejected, and now your lordship may kindly see annexure 9, page number 50, your lordship.
So what is wrong with it? Father
Worship.
died in 2010.
Yes, lordship.
Yes.
Actually, there was no delay on my part, your lordship. Lordship may kindly peruse.
When
page-
did you submit the application?
Lordship, application was submitted on 19/11/2010, your lordship,
Hmm.
and deceased died on 7/11/2010, and petition was filed 19/11/2010, your lordship. Lordship, on earlier occasion, lordship kindly peruse annexure 9, page number 50, your lordship.
Yes, you obtained instruction then.
Lordship, may I submit one thing, my lord, that the petitioner father died in the year 2010. I am relying on honorable apex for judgment regarding that, my lord.
Hmm.
Paragraph 9.1. Lordship, may kindly have a look.
What does it say? You tell me what.
My lord, may I read, my lord? Applying the law laid down by the court in the aforesaid decision to the fact of the case on hand and considering the observation made herein above, an object and purpose of which the appointment on compassionate ground is provided, the respondent shall not be entitled to the appointment on compassionate ground on the death of her father, who died in the year 1995. After a period of 24 years from the death of the deceased employee, the respondent shall not be entitled to the appointment on compassionate ground. If such appointment is made now and on after a period of 24 years, the same shall be against the object and purpose for which the appointment on compassionate ground is provided.
So when was the application for compassionate appointment made in this case?
It is made on time, my lord, but the Honorable High Court had rejected their prayer, then they approached the Honorable Apex Court.
So what is the date? When did the person die, employee die, and when was the appointment application made?
The father died on 1995. Then after a on 2018, she had made application, but in that case, on time, he had made application. But is it
There is
process?
a
is
difference
continuous?
between the two things.
Yes, my lord,
If the delay is because there is no person eligible,
my lord,
then this ratio will apply.
my lord,
But if the delay is because you did not consider it properly,
My
how
lord.
can you, it will be a dangerous thing then.
my lord.
It will be a dangerous thing. Anybody will sit over any application after that it's over. There are orders from the court to consider it.
My lord, DLC is considered again, SLC is rejected for lapse of 5 years of time, my lord.
My case has been rejected twice by the
Take your
SLC.
seat. That can't be done.
Lordship, I will get instruction, lordship may issue notice then. In fact, there is no compassionate appointment scheme right now, my lord. This is another issue. Appoint submitting.
No, but how to deal with this?
Yes,
You
this
have
is
to-
the fault of the government, my lord. They have to examine their cases on time, my lord.
You please request the additional AG to be present next day.
My lord,
I'm not issuing notice, I'm posting it for motion.
my lord.
Again on 25th. 25th of May. We'll see what can be done. If a solution is possible, then only I'll issue notice.
My lord,
But let me first hear. You please
Lord.
request the additional. AG.
my lord,
My query is,
my lord,
the application was on time
my lord,
and you did not process it for one reason or other.
my lord.
You cannot reject it on the ground that there was delay.
Delay,
That you can't do.
lordship,
The delay must happen because of some factor connected with the applicant,
my lord,
not with the government or the
Lordship.
DLC or SLC.
my lord,
That will not accept it.
my lord,
So therefore, if there is no proper explanation why it was not considered properly when it was received in
receive,
2010,
my lord,
then you still have to do it, even because the scheme which was on vogue, the right of the petitioner will ensue under the scheme,
my lord,
not what has happened subsequently.
my lord,
Otherwise, the court will have to stay everything. And
My
then it will be a havoc.
lordship. I will intimate my
You
seniors, my
understood the
lord,
point.
my lord, my lord. Lordship.
That's the.
Because
limit.
SLC rejection is not proper as per my knowledge also, my lord, because there is no delay from their part. Lordship, I will intimate my senior, my lord.
Yes. Heard Mr.
R.H. Chaudhary.
I saw the counsel to the petitioner. Also heard Ms. Amity Bora, Lieutenant Government Advocate Asim. Having heard submission of Lieutenant Counsel for both the sides, this matter is directed to be posted again on 25th of April 2023 as a fixed item, so as to allow, so as to permit Ms. Bora to obtain further instruction.
My lord.
One extra copy of the writ petition be furnished to Ms. Amity Bora.
Obliged.
I am deeply obliged.
Lordship, in this case, I have received Paravas comments. Lordship, may issue notice, Lordship. We'll file our reply, Lordship. It's a claim of MSCP benefits, Lordship.
Will dispose it of heard Ms. Bora, Lieutenant Counsel for the petitioner aggrieved by non-payment of second MSCP benefit due to non-availability of SCR, the petitioner has approached this court seeking a writ of mandamus. Mr. B. Chakraborty, Lieutenant CDC, has appeared for the respondents and prays for 3 weeks' time to file affidavit. Prayer allowed. Issue notice of motion returnable in 4 weeks. Since Mr. Chakraborty has appeared in accepting notice for all the respondents, no formal notice is required to be signed in this case. Extra copy of the writ petition is furnished to the Lieutenant CDC. So as to enable him to obtain instruction and file affidavit.
Already, copy already sent.
In this matter, we have already filed a affidavit, my lord.
I am for respondent number 3 by the. And government filed affidavit. For that copy.
Okay, লাগিব.
What is this matter about?
The Lordship will challenge the selection of respondent number 3, private respondent, as Gaubura of the Borpeta Revenue Circle. The Lordship had granted us an interim protection that his appointment will not be done without proper verification. There is an order to that effect, Your Lordship. The order is of 8th of February 2023. Thereafter, Your Lordship, similar matters have come up before this honorable court. And Your Lordship had also explored the possibility of preferring an appeal under Rule 162C of the Executive Instructions. In that regard, Your Lordship can kindly dispose of the matter.
Yes, ma'am. That is not.
We'll prefer the appeal.
This document. take part of it.
We'll prefer the appeal.
Appeal, they must never happen.
But until the appeal is preferred, Your Lordship, just an humble submission that in any case, the appointment shall not done the proper
That
verification.
cannot be done, my lord.
Appointment has been made already, no?
No, not yet.
All right, you take down, heard Mr. M. Sharma, learned counsel for the petitioner, also heard Mr. T.C. Chutia, learned.
For the others have already appointed, by the way, we have not been given. Other.
Only because of pending of that.
Because we mentioned the case.
Learned Government Advocate Assam appearing for the official respondents, Mr. H.R. Chaudhary, learned Senior Counsel, assisted by Mr.
Islam. J. Islam.
J. Islam is present on behalf of the respondent number 3. Full stop. The petitioner herein is challenging the selection of respondent number 3 for appointment in the post of Gaon Pradhan under charge number 14 of Moja, Nagaon,
Moja.
Borpeta Revenue Circle in the district of Borpeta. On the ground that the petitioner does not fulfill the eligibility criteria laid down in the advertisement notice dated 3/9/2022. As regards non-affiliation to any political party and ownership of land. So stop taking note of the plea of the petitioner's counsel, this court had passed an interim order restraining the respondents from issuing the order of appointment in favor of the respondent number 3 without proper verification of the complaint made by the petitioner. Full stop. Consequently, no order of appointment has been issued in favor of the petitioner till today, respondent number 3 till today. Mr. Chutia submits that since Rule 162(c) of the executive instruction framed under Assam Land and Revenue Regulation 1886 provides for a statutory remedy in the form of an appeal. This writ petition be closed by granting leave to the petitioner to prefer an appeal before the jurisdictional divisional commissioner. Mr. Chaudhary has expressed urgency in the matter, but submits that he would have no objection if the appeal is preferred and disposed of in a time-bound manner. Taking note of the submission of learned counsel for both the sides, this writ petition has been disposed of by granting a week's time to the petitioner to prefer a statutory appeal before the divisional commissioner of, this is what, Lower Assam.
Mojo.
Jurisdictional divisional commissioner. If an appeal is preferred by enclosing a copy of this order within a week from today, the same be considered and disposed of as expeditiously as possible, but not later than 60 days thereafter. Full stop. Until such time the appeal is disposed of, the interim order dated 8/2/2023 shall continue to hold the field. Let them dispose of the appeal. This writ petition stands disposed of accordingly.
Writ petition disposed of, my lord.
Yes.
Obliged.
May I please your lordship? Lordship, this is a matter relating to compassionate appointment. Lordship, the petitioner's father was a AB constable in the office of Deputy Inspector General Police, Silchar, Kasar, Assam. The appointment certificate is annexed in page number 12, my lord. So, after that, my lord, the father of the petitioner died.
When was the application filed?
My lord, the first application was filed in the month of February 1997, but the thing is, the petitioner was not aware of certain things, so he did not keep any copy with himself. After that, another application was filed in front of the DLC, but that also he could not keep. On 4/5/2005, an application he has given through his mother, which is annexed here in page number 22, my lord. Page number 20, my lord. It was prayer for appointment on compassionate ground. They have filed an application on 4/5/2005. After that, my lord, another application they have filed. Is the on,
You say the father died in 1996
yes, my lord.
and the petitioner submitted an application
Yes, my lord.
seeking what? Compassionate appointment?
Yes, my lord.
He submitted an application for his
Uh,
compassionate appointment.
Yes.
What was his age in 1996?
My lord, he was 19 at the age, at that time. He was born in 1983. He was 19 age. Oh, sorry. No, not 19, actually 93. Of 14, 19, 14, 93, 93, 94, 95, 96, 97. He was 15 age, my lord, at that time. But my lord, that does not extinguish his right to for appointment, particularly in respect of compassionate appointment, my lord. Some orders are given by the honorable High
Not
Court.
possible. We'll close this matter.
Lordship, the delay laxes lordship here in this case.
No, this is not laches,
Yes.
but since it is a matter of a scheme, he was not ready, so nothing can be done. Yes, heard, Mr.
S. Afridi.
S. Afridi, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned government advocate, additional senior government advocate, Assam, appearing for the state. First up, this writ petition has been filed with a prayer to issue a direction for considering the application submitted by the petitioner for appointment on compassionate ground. It appears that the petitioner's father, late Basiruddin Majumdar, was serving as an armed branch constable when he died, constable under the Deputy Inspector General of Police, Silchar, Kachar, Assam. First up, he died in harness on 10/7/1996. After that, the petitioner claims to have submitted an application seeking appointment on compassionate ground on 1997.
Yes, my lord.
And thereafter again on
My lord, 4/5/2005.
in the year 1997 and again on 4/5/2005.
4/5/2005.
However, none of these applications are available on record. First up.
My lord, sorry, my lord, the 4/5/2005 application is available. My lord.
1997, but this said application is not available on record. According to petitioner, he submitted another application on 4/5/2005. 2005. But when no action was taken on the basis of the said application, the petitioner had made another application, but his prayer was rejected by the DLC in his meeting held on 31/7/2015. Full stop. Full stop. Aggrieved thereby, this writ petition has been filed. Full stop. After careful scrutiny of the materials available on record, where is the judgment? Miss Bora had a judgment, MD Bora?
Oh, which one?
Huh?
Which
That
one?
delay, Supreme Court judgment she had just read.
Delay to?
A scrutiny of the record, it transpires that the petitioner was a minor in the year 1997, and therefore he could not have made an appointment for, made an application for appointment in a government job. First up. Insofar as the application submitted in 2005, that also, one must note, was submitted after almost 9 years since the death of his father. Full stop. It is no doubt correct that the DLC considered his application and rejected it on 31/7/2015 on the ground of delay. But what is to be noted here in that there was substantial delay on the part of the applicant petition, on the part of the petitioner in submitting his application seeking appointment on compassionate ground. Full stop. In the case of Fertilizer and Chemicals Travancore Limited and others versus Anusri KB bracket civil appeal number 6958 of 2022. The Supreme Court, while considering the validity of an order of rejection of application for appointment on compassionate ground, has held that has held as follows. The new quote, para 9.1. New quote. Having regard to the facts and circumstances of the case, I am of the opinion that the ratio laid down in the case of Fertilizer and Chemicals Travancore Limited and others bracket Supra would be squarely applicable to the facts of this case as well. As such, this writ petition is held to be devoid of any merit and is accordingly dismissed. Yes.
Obliged, Your Lordship.
Me, please, Your Lordship. This writ petition has been filed against the orders passed by the Industrial Tribunal Guwahati.
Just check
Where-
whether this has been reported or not, this judgment.
Industrial Tribunal Guwahati, where it has been, the finding of the court was that, tribunal was that we are not eligible to get the benefits of the award, which was already granted by order dated 11/7/1994 by the Industrial Tribunal itself, Guwahati. What the brief fact of the case, this case is that
Who is appearing for ONGC?
ONGC, actually, we wanted to serve copy, but they did not take, and
Then we'll issue notice at this stage.
yes, Lordship.
Heard Ms. S. Dasgupta and counsel for the petitioner. There will be amendments made in the writ petition. Issue notice of motion returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondent by registered post immediately.
Thank you, blessed.
Item 13.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? Lordship, in this case, petitioner before Your Lordship is a son of the ex-Gaon Pradhan Lordship. So basically, in this case, Lordship, we have challenged the selection process of the respondent number 3, Lordship. But in this case, what happened, Lordship, we have filed the appeal in the month of Lordship, November, 28 November 2022, Lordship. But since then, no appeal number, no process has been assessed till today, Lordship. We have filed the appeal, Lordship.
You filed the appeal where? Before whom?
Commissioner North Assam Division, Lordship.
Not as some, we may come along with the instruction also.
You find out.
Yes.
When you find 25th, we'll
Yes,
post
Lordship.
it. Motion 25th. Heard Mr. R. Borwal, learned counsel for the petitioner, also heard Mr. J. K. Goswami.
Can be on 21st, Lordship.
21st,
21st, Lordship, 25th.
there is holiday in between. huh? You are not available on 25th.
Lordship.
It will with some difficulties, Lordship. If Lordship is satisfied, then 22 is suitable.
22 is very difficult.
Yes,
It's
Lordship,
a holiday.
yes. Yes.
Then we do it on 26th.
No,
26.
So Mr. Jacob Goswami, learned additional senior government advocate Assam, prays for time till 26/4/2023 to obtain instruction and appraise this court as to whether the statutory appeal filed by the petitioner assailing the selection of the respondent number 3 for the post of Gaon Pradhan has been considered by the divisional commissioner and disposed of in the meantime. First of all, one extra copy of the writ petition be furnished to Mr. Goswami. List this case again on 26/4
Deeply obliged.
for motion.
Item 14.
May it please your Lordship. Lordship, the petitioners are trade union representing workers who work in Nagaon Paper Mill. Nagaon Paper Mill is a manufacturing unit of a wholly government of India owned Hindustan Paper Corporation Limited, HPCL. HPCL suspended operations in 2017.
in 2019, liquidation was initiated. The workers and the employees moved the NCLT for disbursement of salaries, etc. And the NCLT said remedy lies elsewhere. There was a proposal for, because it's a government of India undertaking, there was a proposal to pay their salaries from consolidated funds. That didn't work out. Finally, the government of India said that, we are unable to offer a scheme of restructuring or relief. That is when in 2021, Your Lordship, Government of Assam stepped in. And Lordship, kindly take a look at page 88. They offered the scheme for relief. And it was more a form of an agreement between the workers and Government of Assam. So they literally came into rescue. Minutes of the meeting of Honorable Chief Minister, Assam, with representatives of all, Lordship has page 88?
Yes, yes.
Yeah. Of all unions and association of Hindustan Paper Corporation Limited under liquidation on 20th of September 2021. After detailed discussion with the unions and association of HPC Limited, the following decisions were taken unanimously. In view of sufferings faced by workers and employees of HPC Limited due to present status of both mills at Jagi Road, Panchkuram, Government of Assam proposes to offer a general relief package to them. 2. Government of Assam will approach the NCLT through the official liquidator for taking over the assets of HPC after due diligence. 3 is what concerns the writ petitioners. For assessment of quantum of relief to be given to the workers and employees of HPC Limited, the following claims will be taken into consideration. A, provident fund, gratuity, pension, full payment. So there was an agreement, Lordship, and in principle, they agreed to pay all of this, for which they will take over. And Lordship may see page 91, it's a signed, it's all the representatives signed it, page 91. Lordship, this happened in September. After that, the Supreme Court came up with a judgment. And the Supreme Court judgment actually basically reiterated what the IBC said. And IBC basically says that Provident Fund is sacrosanct under 36(4), and you can't touch it, even for recoveries under liquidation. That's section 36(4). Now, Lordship, the Government of Assam has somehow misunderstood that judgment. Lordship, may kindly take a look at page 115. They are in principle agreed on this, but for some reason they read the judgment differently, and which is why they said that, we don't want to enter into it anymore. Lordship has page 115.
Yes.
The first paragraph talks about the meetings, and it also refers to the 20th September 21 meeting that I just read out. Second paragraph, AIDC, Government of Assam, on behalf of Government of Assam, has registered the land of both the mills, Nagaon Paper Mill and Kachar, in the name of, so the land has been transferred. Third paragraph is what's crucial for us. The Government of Assam has had a meeting with unions and associations of HPCL to settle dues and claims on 20th September 21, and a relief package was proposed by the Government of Assam as an outcome of the discussions. Meanwhile, the Honorable Supreme Court, so-and-so, has given a direction that the deficiency in CPF and gratuity will not be met from the liquidation amount. Lordship, there's a bit of a misunderstanding in this. As a result, now the workmen and employees of erstwhile HPCL will not get gratuity and pension out of liquidation amount, and in that place shall be given a portion of the salaries due to the workmen for only 24 months prior to liquidation. This has resulted in a chain of modalities of the relief package proposed by the government earlier. It is observed that the above order of the Supreme Court will be applicable in the instant case of HPCL, is subject to judicial interpretation, and today's meeting decided not to enter into this matter. So, Lordship, I can place the judgment of the Supreme Court. Basically, Supreme Court read the IBC and reiterated that the Provident Fund is sacrosanct. It belongs to the people whose salaries have been deducted. So when a company goes into liquidation, you can't touch that. For disbursal of recoveries, that doesn't become the liquidation asset. So it's actually outright protection to Provident Fund, which they have somehow misunderstood. To say what the court said is you can't touch that for giving other people, for secured creditors and etc. That's sacrosanct, that goes, section 36(4) says that goes only to the Provident Fund beneficiaries. Now that has been misunderstood, which is why we've come here, because it's a judicial interpretation. And Lordship, now what has happened actually, Lordship, is there is a deficit in the provident fund. The management has not contributed. So now there is no provident fund to disburse. Now, in such a, IBC doesn't take care of that situation because IBC contemplates that there is a provident fund existing and there is monies in that. In which case, don't touch it. Give it to whoever it belongs to. And for rest of the recovery secured fund, you go up to the liquidate. That's what the Supreme Court judgment said. Now, what happens in a situation where the management did not contribute? That there is about 100 crore that has not been deposited by the management. In such a situation, the employees' provident fund comes into being. And it says that in a situation like this, 10-4. In a situation like this, the first charge on asset is the provident fund. Perhaps the government was not aware of that. So they just, a prayer is that you may issue notice to the government so that, this controversy can be this thing, because in principle, they're okay about it. They just think that the Supreme misunderstood the Supreme Court judgment to come in the way of their relief package.
Will issue notice that?
Yes, Your Lordship, yeah.
Pardon, G. Goswami, learned counsel appearing for the writ petitioner. Peruse the averments made in the writ petition. The basic contention of the petitioner's counsel is that on an erroneous construction of the order passed by the Honorable Supreme Court in Civil Appeal number 5910 of 2019, dated 19/4/2022, pertaining to CPF and gratuity of the members of the petitioner union, the government of Assam is seeking to deprive the employees of the erstwhile HPC paper mill by acting in violation of the memorandum of settlement. Is it? They are residing on the memorandum.
Yes. On the basis of
by going
fair to the government of Assam,
and are
they're not trying to deprive, they're just trying to misunderstand the judgment to say it's come in the way.
so in an erroneous interest, so the government of Assam is acting in a manner prejudicial to the interest of the members of the petitioner union. Mr. A. Kalita, learned standing counsel, Industry Department, Assam, and Mr. J.K. Goswami, learned government advocate, Assam, have prayed for 6 weeks' time to obtain instruction and file affidavit. They are allowed, issue notice of motion returnable in 6 weeks. Since who is appearing for whom? One.
I may take for respondent number 3 years.
I am appearing on behalf of 2 and 4, Lordship.
Who is for one?
One CGC.
Since Mr. S.S. Royal and CGC has accepted notice for respondent number 1, Mr. J.K. Goswami, learned additional senior government advocate, Assam, for respondent numbers
2 and 4, Lordship.
2 and 4. Mr. A. Kalita, learned SC, Industries Department, for respondent numbers
3 years.
respondent number 3. And who is for?
And for the respondent number 9.
And you for?
Respondent number 6, Provident Fund.
Mr. S. Chakravarti, learned counsel, for respondent number 6, and Mr. P. Agarwal for respondent number 9. Service of notice in those upon those respondents is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned standing counsel. Petitioner to take steps for service of notice upon the remaining respondents by registered post to lady. Petitioner to take steps.
This is a matter related to transfer of the petitioner, writ petitioner. And it has been stayed. We have filed an application for vacating that order.
Applicant.
I am the applicant. Petitioner, application to the. It is at page 15 mirror of the IA. Page 16. 15/16.
12/5/22. I'm for the petitioner.
What is DO? DO? What is DO?
Divisional office.
Division.
Yes, yes.
This has been in pursuance to the inquiry committee's report, because there were complaints by the co-workers. We got an inquiry, internal inquiry. And that is at page 43, your lordship will find.
Page 43.
It starts at page 39, that is the report. Page 43 is the. Also, they vouched for the professional so-and-so managerial qualities of the senior division manager. They further stated that the urgency of the need to transfer Sri Debasri Chaudhary from the Silchar office, as they were of the opinion that she was spoiling the work environment, culture of the office, which is demoralizing effect on the staff, officers and agents. Besides, Srimati Nasulita Nath so-and-so, on being specifically asked if they had signed for fear of displeasing the senior divisional manager, refuted the charge and stated that they had not signed it. That therefore the inquiry was conducted on the basis of the complaint of the co-workers. Complaint is dated, my lord, 36, page 36.
Yes, so the writ petition, what will remain if the stay is vacated? Writ petition should be heard. You argue on the writ petition.
My lord, that case, my lord, let it come for admission sometime in May, my lord, and disposed of.
No, what remains in the writ petition?
That is correct. The writ petition gets disposed of.
Yes.
So she has to make submissions on the writ petition first.
Not ready today.
Not ready to, because some judgment should be required, my lord, because this is punitive in nature. It is very apparent on the, my lord, from the, whatever the document they have now enclosed with this.
But how many years have she, it's a transferable job.
Is it transferable?
How
But
many years she has
It is
completed?
not on administrative exigency, my lord. The very, my lord, opening letters of this order, my lord, impugned order, says that it is in the nature of, my lord, disciplinary proceeding. If there was a disciplinary proceeding, what they are trying to, my lord, say in.
All right, we'll ask them to proceed against your client and punish her.
My lord, that is, of course, then.
But
then
we
I
did
get-
not want to
then-
punish her.
Then I get chance to defend myself, get those documents which are against me. Nothing has been followed. Simple, they are saying now that this is also, my lord, I have stated.
She is not willing to relocate herself at Guwahati.
No, she is staying alone. She is a single lady and therefore, my lord, she had some difficulty here. Therefore, she shifted to Silchar. Has some my lord, physical issues also, like I mean, health issues.
Guwahati is a better place. Is it not? People come to Guwahati.
Actually, my
with
lord,
health
in this case, what hurt her, what I understand is that she had lodged a complaint against a senior officer against sexual harassment in the workplace. So as against that complaint, no action has been initiated. And all these has come as a sequel to that to her
But
complaint.
there is no complaint of sexual harassment.
It is there, my
Where
lord.
is it?
It is there, my lord. In my petition, I have stated.
Yes.
In my application also, it is there, my lord. And there is a report also. Complaint is dated, my lord, page 36.
Report says it's time barred, more than 1 year.
Yes, that is.
Yes, my lord.
Yes.
But where
So
is
how
the
can-
allegation of sexual harassment
It is,
here?
my lord, annexure 6, page 25 of the writ petition, my lord.
No, in the IA also it is there.
In the IA also, it is there, page 36, my lord.
It's 36.
Page 36.
Yes. No, which part is the complaint regarding sexual harassment in workplace? Can you please point out?
Yes, my lord. The very first page, when on Friday evening, I went to him seeking advice relating to a mediclaim file, and it was then I requested him to provide me with additional diary, which being a bit thoughtful, he told me that Rashim has got it, my lord. From bottom, my lord.
Page 36.
Page 36 itself, my lord. Seventh, eighth line, my lord, from bottom.
Yes.
Therefore, he provided me with a solution to this by saying that the following day, being holiday, that is Saturday, he proposed me to come to his office on that very day, whereby he said that he found me quite different from others, and in my deliberations, so he would like to spend some quality time with me along with some, since no one would be there. It would not be a problem on his part to provide me the additional diary, to which I understood his hidden intention as per the proposal being sudden, and never in my entire lifetime have such proposal from anybody. It did took me to some seconds to react to this after, while grasping the same situation and not to complicate it further, I politely denied and that it would not be possible on my part to attend office on such day. I would be accompanied by my aunt.
So how is it a sexual harassment? He has asked her to come to the office on a day when it is a holiday.
My lord, after that, my lord, he started harassing her every day. There's a
How? Where are the
details,
particulars? Where are the
like,
particulars?
my lord.
How? Harassment in what manner?
She was, my lord, given some work which she was not supposed to do. She was, every other day, she was transferred to some other section and she was forced to do those, undertake those works, my lord. Thereafter, on several occasions, I have been verbally abused by him, where he abused me, saying foolish, childish, and lessening the demeanor of the company, made these remarks in front of policyholders. On occasion, he yelled me in front of policyholder and told me to get out of his room. He trusted me.
If these are to be treated as sexual harassment, it will create a very anomalous situation.
My lord, the veracity of her
Come to
complaint.
office on Saturday, sexual harassment.
My lord, veracity of those statements, whatever, maybe whatever allegation she has made, those were not correct. But there is a procedure prescribed. They have not followed any procedure. Now, they have enclosed some documents here that they have done some inquiry. It was only afterthought I have made statement in my reply also.
So you are not asking here some action to be taken on her complaint on sexual harassment.
Now,
not the relief.
I'm against that order impugned is the order of transfer, that it is punitive in nature. You find me that some inquiry has been done, which is not in proper form.
That's what I'm
And then-
asking. So we'll set it aside and ask the department to proceed against her in a departmental proceeding and punish her if she is found guilty.
That is of course up to them, my lord. If they think a disciplinary proceeding can be initiated against her for any my lord, misconduct, then it is open to them,
She
my
will
lord.
be open to that kind of an order.
It will be open to them, my lord. That anyway.
No, but if you make this stand that it is punitive, they say that there are complaints against her. So instead of, meaning is instead of initiating a proceeding, we are transferring her. There are judgments we say is permissible.
Yes.
That's what I wanted to place, my lord. Let it be on in the month of May, my lord, sometime.
All right, both of you decide on a date.
Well, I am hard pressed, that is the problem. But Lalit Peri is difficult.
You are for whom?
I am for the insurance company.
Company.
Respondent.
All right, but almost a year has gone, so you can wait
Yes.
for another 10 days.
That is correct. Yes.
I heard Mr. B.C. Das, Lalit Senior Counsel, listed by Mr. So-and-so, Lalit
Yes, it's
Counsel,
wrong.
appearing for the applicant. Also heard Ms. P. Chakravarti, Lalit Counsel, representing the opposite parties to agreed petitioner. This IA has been filed with a prayer to vacate the interim order dated 12/5/2022 passed by this court in WPC number 3113/2022. After hearing the preliminary arguments advanced by learned counsel for the parties, this court is of the opinion that instead of taking up the IA, the writ petition itself should be taken up for final disposal. As such, and on the request of learned counsel for both the sides, registered
No, that 15 by different.
registered to list this IA along with the connected writ petition for admission hearing on
Not 15th of May. My senior has no problem.
15th আগে করো না একটু আগে যদি করো আগের সপ্তাহে করো
12th of May 2023. Interim order passed earlier to continue till then.
Could it be, well, can it be on 11th? Because, আচ্ছা ঠিক আছে let it be.
Please, your lordship. Lordship, the IA is filed by the respondent number 7 of the writ petition, lordship. Lordship, I am, by way of this interlocutory application, I am praying for modification of the order dated 39/2022 passed by the honorable court, lordship, that is annexure 1, page 11 of my file. Selection of Gaon Buha, lordship, that was kept in abeyance by the interim order.
You are for the petitioner.
Lordship.
You prefer an appeal?
Lordship, the direction I will prefer an appeal, lordship.
We'll
Till
close
that,
it.
lordship, as no appointment is there, lordship, till that, lordship, still interim order may be continue, lordship.
All right, give the petition. We'll
Lordship,
give her 7 days time to prefer an appeal.
Lordship.
To take down, heard Ms. G. Bora, learned counsel for the writ petitioner, also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the respond numbers 2 to 6. Ms. M. Devi, learned counsel is present on behalf of respond number 7. First up, assailing the selection of respond number 7 for appointment in the post of Gav Pradhan. The instant writ petition has been filed internally contending that the respond number 7 does not meet the eligibility conditions prescribed by the advertisement notice dated what is the advertisement notice? Date of the advertisement notice? Advertisement notice dated?
Not sure. Advertisement is at 5/9/22. 5/9/22, no?
10/4/2008. What is the date of the?
These are the coming years.
His lordship, it is,
22/9, 5/9/22.
In the advertisement notice, first up.
29/2021, Lordship. Advertisement, I have,
Where, which page is it?
the date is not there, Lordship.
It is
Not there, Lordship.
in
So,
annex.
but I have written that at paragraph number 2, Lordship, page number 5, Lordship.
All right, 29/2021.
Lordship.
By taking note of the projection made in the writ petition, the learned signal that while issuing notice in this case had passed order dated 30/9/2022, restraining the respondents. Now, directing the respondents to keep the selection and appointment of the respondent number 7 in abeyance until further orders. The respondent number 7 has approached this court by filing IA civil number 661/2023 with a prayer to vacate/modify the order dated 30/9/2022. First up, Mr. J.K. Goswami, learned additional senior government advocate Assam submits that the writ petitioner has a statutory remedy in the form of an appeal preferred under Rule
162C.
bracket C, bracket close, of the executive instruction issued under Assam Land and Revenue Regulation 1886. And therefore, this writ petition be disposed of with a direction upon the respondent, upon the writ petitioner to avail such statutory remedy. The learned counsel for the writ petitioner as well as the respondent number 7 have also agreed to such a recourse. First of all, it is also confirmed that no appointment order has been issued in favor of the respondent number 7 till today. In view of the above, this writ petition is hereby disposed of by providing that within 7 days from today, the writ petitioner may prefer an appeal before the jurisdictional divisional commissioner. Full stop. If an appeal is preferred within 7 days by enclosing a certified copy of this order, it will same be considered on merits and disposed of with a reasoned order. After looking into the allegations brought forward by the writ petitioner, the aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 60 days from the date of receipt of the appeal. Full stop. Until such time, the appeal is disposed of, no order of appointment shall be issued in favor of the respondent number 7. With the above observation, the writ petition as well as the IA number 661/2023 stands disposed of.
Your Lordship, I may be given an opportunity of hearing in the appeal proceeding.
I don't know where you last of all. The respondent number 7, we also heard before a final order is passed in the appeal. Until such time, the appeal is over. Yeah.
Obliged.
May I please, your lordship? My lord, this interlocutory application has been filed for impleading Sri Sakradhar Borua, who has been now serving as the assistant manager and in charge of Psychotherapy Estate in place of earlier manager, your lordship.
What has happened to the earlier manager?
He has been transferred to another tea estate, your lordship.
Yeah, please, your lordship, the senior counsel is out of station. Kindly adjourn the matter today.
Who is senior counsel?
He does.
Next week? But Mr.
P. Golita.
C. Kolita, learning counsel for the applicant, Miss
A. Hazarika.
A. Hazarika, learning counsel for the respondent submits that her senior is out of station and therefore this matter be taken up after 10 days. Prayer allowed, list the case accordingly.
Must.
Maybe, Lord, the contender numbers 2 and 3 has already been retired, my lord. So in their place, my lord, the respondent number 4A and 4B should be added at party respondent number 5 and 6, my lord. Page 7, para 5, we have more text.
Where is respondent number 4 and 4B? I don't find anyone.
My lord, page 5,
Respondent number 4A and 4B.
my lord,
Where is it? Show me.
page 5, my lord.
No, in the arrow party, where is 4A and 4B?
Yes. Okay. Must be correct, no, this. Sorry, my lord, it is 5 and 6, my lord. In my copy, my lord, 4A and 4B.
Your copy is, you know, we don't know. Or you give me your copy. So who is to be implemented?
My lord, on my lord, Niren Borua, civil engineer, and my lord, Topon Pukon, executive engineer.
Heard Mr. M. Mondal and a counsel for the applicant. This IA has been filed with a prayer to implement the opposite parties numbers 5 and 6, namely Sri Niren Borua, Chief Engineer, PWD Building, and Sri Tapan Pukon, Executive Engineer, PWD Buildings, Division Dhubri, Assam, as respondent numbers 5 and 6 in the connected contempt case on the ground that with the transfer of the earlier incumbents, these respondents are now responsible for implementation of the court's order. Going through the statements made in the IA as well as the submission, as well as on hearing the submission of Mr. Mondal, I am inclined to allow the prayer made in this application. As such, the opposite party numbers 5 and 6 are hereby directed to be implemented as respondent numbers 5 and 6 in the connected contempt case. Register to make necessary endorsement with the cause title of the contempt case and list the matter for orders. Highest stands disposal.
Developed.
For admission,
Lordship, before my learned senior submits, actually Lordship desired that what will be the total liability of these employees if your Lordship holds that this is a retrenchment. That was Lordship asked me to get this figure. But department Lordship, I have spoken to them, they need Lordship 1 week time for that, at least 1 week time. They are doing it because Lordship, these people who have been, already transferred to the, they have been taken over by the private respondent. So what is happening, that there is some difficulties in calculating this 1 week time, Lordship. If you can accommodate, then we can finish it.
All right,
up.
heard Mr. A. Dasgupta, learned senior counsel appearing for the writ petitioner. Also heard Mr. A. Kalita, learned standing counsel, Industries and Commerce Department, Assam, who seeks 1 week further time to obtain instruction as called for by the earlier order of this court. After considering the ground on which the-
No, so far he is concerned, he told me yesterday, that for the purpose of calculation.
Yes.
Only, but that may kindly be recorded, otherwise the matter may
After
be.
hearing after considering the request made by Mr. Kalita, admission hearing of this matter stands defers till 27th of April 2023. Registry will list the case accordingly. 27th April.
Lordship. Obligation.
Why is 5th May a holiday? Can you just check it?
One of item 24 pending. Lordship, in this case, on last occasion also, I prayed for some time for obtaining instruction, Lordship. Lordship, today morning I received one letter from the department. They are praying for some more time, Lordship. Lordship, in this case, we have
No,
filed
but
on.
why are they praying for more time?
No,
Why?
they filed one additional affidavit, Lordship. There, the ground for rejection of his promotion, Lordship, one of the ground was that his appointment was done by some other department, not under the Secretariat Administration Department. So his seniority will not be counted under Secretariat Administration. In response to that, Lordship, we filed one additional affidavit trying to show that no, his though his appointment was not under the Secretariat Administration.
What is the prayer here?
Promotion.
Petitioner is praying for a similar relief, wherein a person junior to the petitioner, he has already been considered and given promotion by this persons to order passed by this honorable court. And the ground for rejection of that person was also similar to the present petitioner. If your lordships kindly take, even if Milord, this honorable court raised the query pursuant to that, Milord, I filed the additional affidavit. Even if we don't go to the additional affidavit, on the face of it, Milord, the petitioner is entitled. Because the person who, Lordship will kindly take up the order passed by this honorable court.
So he wants time, you are not agreeable to that.
Milord, I filed the additional affidavit in the month of January and today is April.
That is
I'll have to
that was
justify
the
my
basic
time
ground
also,
for
Milord.
rejection of his case, Lordship. His appointment was not done by the Secretariat
So
Administration.
are you ready for the final hearing today?
Lordship, that instruction, I think, requires Lordship. Because that was the point raised in the additional affidavit. Otherwise,
Last chance, no further time will be granted. I heard Mr. H.K. Das, learned counsel for the writ petitioner. Also heard Mr. P. Nayak, learned standing counsel, SAB. So when this matter was called up today for admission hearing, Mr. Nayak has once again prayed for time to seek instruction on the core issue involved in this proceeding, which pertains to the ground on which the prayer of the writ petitioner was rejected by the authorities. Considering the ground on which such a prayer is made, the same stands allowed as a last chance. Register to list this matter again on 18th of May 2023 as a fixed item.
Obliged.
I leave.
Lordship, on the last occasion, direction was given to obtain the instructions whether he may be permitted to avail the pension or not. This order it.
Ever received the instruction?
Yes, Lordship, as per my instruction, Lordship, he is not entitled to any pension because he has resigned from the service. And even it is considered that he is discharged voluntarily discharged from service. In that case also, Lordship, he is not entitled to any pension because under CCS pension rule, there is no concept of voluntary discharge. So, and if it is considered as resignation, then his past service is forfeited. So, no amount of pension is he entitled to. Only under leave rule, he will get lordship case equivalent to the extent of half of earned leave. Only that amount he will receive.
So have you mentioned it, what he will be entitled to?
Yes, lordship, in my instruction, lordship, it is stated that.
Let me see. Can you show him a copy of the instruction?
Last paragraph,
Hmm.
last paragraph.
Mr. Bezbura, Lordship, take the order of dismissal after 2 weeks.
Lordship,
Today I will write a short order. What do you want? His conduct is absolutely unacceptable.
Yes, Lordship.
10 times he remained unauthorized. He deserted the camp 10 times. 11 times overstayed leave. Twice he resigned. Now he wants everything from the service.
Yes, Lordship, I take it up after vacation, Lordship. I will satisfy your Lordship. Here is it.
Acha, in terms of the order dated 24/1/2023 passed by this court, Ms. L. Devi Lanet, Ms. R. Devi Lanet, CGC, appearing for the respondents has obtained written instruction dated 2/3/2023 and placed the same before this court. I have perused the instruction, placed the same before the court. According to the written instruction, the petitioner will not be entitled to any pensionary benefit as prayed for. If that be so, this writ petitioner would now have to be decided on merit. As such, and on the request of learned counsel for both the side, let this writ petition be listed again for admission hearing after 4 weeks.
Much obliged. Item 25.
Wait, the lordship.
Yes.
But in this case, the petitioner of the lordship is praying for payment of salary, my lord, from the date of his initial engagement. My lord, though he was engaged as on contextual basis, my lord, on 1/1/2009, under the respondent number 5, he was not paid the salaries.
Where is the order of appointment?
Yes, my lord, that is page 39, my lord.
Page 39.
Yes, my lord.
There is no
In
39.
the
there.
additional affidavit, my lord, page 4 of the additional affidavit, my lord, running page 39.
What is this order? Somebody just writes 2 lines, he is appointed. That's all. Was there a selection process?
No, my lord.
Was there any vacant post?
No, my lord.
Then
I am
what-
not claiming for salary, my lord, regularization, my lord.
Hmm.
I am
What
claiming.
was
only
the salary? What is the salary?
My lord, the computer operator is a grade 3 post, my lord.
Hmm.
Grade 3 post, and I am entitled to the salary of the grade 3 post, my lord.
No, but have you got the salary ever?
No, no, my lord, never.
What is this kind of order?
Lordship, in our affidavit and reply to the additional affidavit also, we have stated, Lordship, there is no sanction post of computer operator.
Either take action against this executive engineer or pay him salary from the date of his appointment. choose the option you want. You can argue for whole day.
Lordship,
but
Lordship, action may be taken because he is not the appointing authority.
why did you do it then?
Yes, Lordship, that only on the filing of this record, writ petition and going through the records. Lordship, we found that there is no existence of this letter and the number that has also been given. And nothing is there, Lordship.
Who is this officer?
Lordship, it will have to be found out with regard to the relevant period of time, Lordship.
My lord, for my instruction, my lord, I have, as per my instruction, my lord, they, after filing this petition, my lord, as per your lordship's direction, dated, my lord, 22/2/2023, they made an inquiry, the respondent authorities, my lord, they made an inquiry, my lord, asking all those officers, my lord, who issued certificates to the petitioner. And all the officers, my lord, they admitted that they issued those certificates.
Where is that?
That they have not annexed, my lord. They only says that these letters are not part of their record. They have not stated that.
No, Mr. Sekia, first of all, question of granting any relief does not arise. Just because somebody somewhere just issues a letter, that doesn't make it legitimate. The process has to be legitimate. Listen. Even if you don't get relief in this case, it will help you in some other case. Try to know the law. It will help you. You can't enforce this kind of letters in a writ petition. That's the law. If somebody, in some court, some proceeding, some order is passed, that is a different matter. I am talking about what is the legal procedure. An appointment in a government post can be made only by the competent authority and by following the proper procedure. If there is no vacant sanction post, these orders are illegal. We will ask them to lodge an FIR and proceed against the person who has issued it. That's the only order we'll pass here. Every citizen must know that just because somebody hands over a letter, that is not appointment. If somebody accepts that, he does it as his own peril.
That is.
Nothing can be done, nothing. We'll take up.
That is the practice of the authority since
That
90s.
practice will stop.
Since 90s, my lord, they are engaging persons like.
Mr. Chaudhary, I am
accepting
making
service.
very clear. I am shifting this matter by a week. Either you show us that you have lodged an FIR and initiated disciplinary proceeding against this person, or there will be a writ of mandamus to pay him salary of grade 3. And we'll not even dispose of this matter. We'll monitor it.
Yes, Lordship.
These jokes have to stop. Who is this executive engineer? He issues the appointment order in the interest of public service. So and so is hereby temporarily appointed as competitor for smooth functioning of the divisional office until further orders. What is this order of appointment?
Lordship, I can't say, Lordship, it may be stopgap arrangement. Or and that doesn't give him the right to continue.
No, if he is done the right thing, then it definitely gives him a right.
Yes.
Only way he can be denied right if you can show that if this man is punished. Otherwise, you have to pay him the salary. I'm making it a fixed part-heard matter.
Yes,
Even the chief engineer also forwarded my case to the
Then
secretary.
they will have to pay from their pocket.
Yes, Lordship.
We will simply direct pay him grade 3 salary and deduct it from the pensionary salary of this. That is the order which is coming. Heard Mr. I.S. Sekhar and counsel for the petitioner also heard. You give us the name of the people who are responsible for the issuance of this order.
Yes.
And the names in the period of service and what action has been taken against them. Also heard Mr. B. Chaudhary, learned standing counsel PWD Assam, who prays for posting this matter again on 15th of May 2023, so as to enable him to obtain instruction and appeal this court. As to the officer, bracket S, bracket close, responsible for issuance of the order of appointment dated 1/1/2009. And steps, if any, have been taken against those officers if the order of appointment is found to be illegal. This matter shall be listed again on 15/5/2023 as a fixed part-heard matter. If we find that they don't take any action and the salary will be paid from their pocket, from their.
They will have to take action against all those officials, my lord,
They will
who
have-
have utilized
will
my
have-
service.
They are just, there are people from both sides who are just generating litigation.
Yes, ma'am.
We will stop it. A time has come when we'll stop it. Salaries will have to be paid by these officers. Their pensionary dues will deduct and pay it to them.
Yes, Lordship.
Unless something like this is done, this will not stop.
Yes. Obvious, ma'am.
May it please your lordship. Your lordship, there is matter for regularization and non-payment of dues since the year 2016. Now, your lordship, the respondent number 2 has filed his affidavit. But however, the respondent number 1 and 4th affidavit would be required. One is the commissioner and secretary, and 4 is finance department.
Who is appearing for the handloom and textile department?
State of Assam. Earlier, your lordship, the state of government advocate has received notice.
Who is the standing council, handloom and textile? Catch hold of Mr. Dhar. Let him come.
Okay.
May I please, Your Lordships? It's a matter of compensation ground service. Petitioner's father died on 2/11/2010. Then mother of the petitioner filed petition within time, because at that time the petitioner is the minor at the age of 16 years. Hence, the mother applied for her daughter. In the meantime, the daughter was already married. Hence, second petition also filed by the petitioner, mother of the petitioner for the second petition filed on 23/2013, and first petition within period 25 to 2011. In 2023, the daughter of the petitioner, mother of the petitioner is already married. Hence, 23/12/13, another petition was filed. But in DLC, that's on 1 to 2022, this page number 28, rejected our prayer as that the proposal of the Chiranjeev was placed on discussion, but it was observed that the applicant had applied after 1 year from the date of the government servant. Hence, the proposals could not be recommended for the late of submission of applications.
What to do? That was the norm. At that point of time.
At that time, I'm at the age of 16 years, and I have minor. After I get majority, I'm file the petitions.
It can't be done.
But my sister's petition is not there accepted.
No, but
for
your
2 years.
sister has not come. You have come.
No.
That she has got married. She already married, so she has left her.
That's right. So the petitioner has come before the court.
She need not, she already gave them no objection certificate, says I have no objection. File a petition, then if my brother is applied for
When
this
did
post,
the petitioner file the application?
2013, when he get the measure.
Right. So at that time, the standing circular was that within 1 year, the application has to be filed. Correct.
Yes.
It was not
My
filed
lord.
within 1 year.
Now already filed by 1 year, but in the name of my mother approach for the my sister, because I am the.
Your miss, your name, please.
MP Methi.
You are not understanding the query. We are going to consider only the case of petitioner, not his mother or his sister. They are not before the court.
Yes, my lord.
Petitioner's application was filed 3 years later.
Yes, my
So
lord.
they say it is barred by time because within 1 year the application was not filed. What happened to his mother's application, sister's application? We are not going to go into
Yes,
that.
yes, my lord. But at that time, I'm minor.
Maybe that holds for everybody.
This I get a majority on
There are
2012.
very hard facts. Sometimes the children are 2 years, 3 years old. But can they, after 16 years, can they come and file?
No,
an
no, no, I am at the time of 16 years. So after getting majority, I filed.
Within 1 year, it has to be filed. That's the Supreme Court decision. If you are a minor within 1 year, then it is gone. That's the law. What to do? Have you read the Supreme Court judgment?
Yes, yes, my lord. But
It sounds very illogical, but that's the law. For whatever reason, even
Yes,
including you're a minor,
Mm.
if it is not filed within 1 year, at that point of time, there was a circular. Nobody challenged that circular. Or it was not set aside even if challenged. The government will go by what is there in the circular. The SLC has to follow that. So SLC is not wrong.
Yes, my lord, but petitioners filed.
DLC, not SLC. DLC rejected.
DLC rejected.
That's it.
Yes.
DLC is rejected.
Petitioners filed. No doubt it was by due to my measure, minority.
She has
minorities filed.
understood, but she is now not going to admit that she has understood. When do you want the order of dismissal? Today or after 4 weeks? You can choose. You understood the point very
Yes,
well.
yes, my lord.
Nothing can be done. Hundreds of orders have already been passed on this ground. That when the notification was in force, the DLC will follow the notification. That notification has not been set aside. There are many cases, hundreds of cases where people are minor, would not apply. On attaining majority, they applied. The court has not entertained.
In my lord, just a minute. In Tripura High Court, there's an case Subham De versus State of Tripura. He didn't then same quality.
This same notification, Assam government notification was there.
That's same there. Notification is different, but due to the age.
See, what is the question here? Was the DLC right in its stand or was it wrong?
Yes, my lord.
If the DLC followed the government instruction, it is right. If they did not follow the government instruction, they are wrong. The government instruction was within 1 year. There are judgments of the High Court, division bench, which says whatever be the reason, you have to file it within 1 year. If you file it within 1 year and the DLC has kept it pending for 10 years, this morning also we dealt with a case. There the matter will be different.
Within 1 year, we filed a petition, but till now, this petition was not there.
No, petitioner did not file.
The petitioner did not file. Petitioner did not
That
file. The
is
mother of the
absolutely-
petitioner filed because he is a minority. This is not is.
How does this court pass an order which is different from all, so many orders already passed? You check up, do some research,
Yes, my lord.
give me a way out. I'm willing to help,
Uh,
but not in a manner which is not permissible.
Prefer further hearing, my lord.
Hmm?
Prefer further hearing. If
Further
you
hearing?
fix,
Okay, how much time you want?
1 month, my lord.
1 month?
Uh.
This bench will not change.
Yeah, definitely, my lord.
All right.
I want
The
you. my
request
lord.
of Ms. Medhi Lanik, counsel for the petitioner, made with the consent of Mr. T. Sutia, Lanik, additional senior government advocate. Assam. Appearing for the respondents, this matter be listed again after a month for admission hearing. Do some research. If you can show me a way out,
Yes, my lord. I will try
Then-
my best. my lord.
definitely do it.
Yes, I'll.
But the
May I
court-
add this, my lord? In a Khadim Hussain case, Honorable Apex Court held that the case is that, my lord, the petitioner mother applied, but department did not consider her case. Then when the petitioner attained majority, he has filed the application. Then the Honorable Apex Court has directed to consider his case. But in the Sanjay Kumar case, lordship, it is stated by the Honorable Apex Court that there should not be any reservation for a minor. When he should attain minority, his case should not be considered.
Can you give her both the judgments? Give her the.
State of Manipur versus another case. Cannot be given back.
Give her the judgments, let her satisfy herself. If she can come up with a argument, I will consider it. But yes, that is the problem. Now you know,
Yes,
there are already cases.
Yes, my
decided.
lord.
Yes.
Highly obliged, my lord.
Yeah, please, your lordship, my lord. This is also regarding compassionate appointment, my lord. My case has been forwarded by the DLC, my lord, but the SLC
Only
has been-
compassionate. You need a compassionate court for compassionate appointment now. So many cases. What is the point here?
My lord, the district level committee has recommended, but state level committee has not yet considered, my lord.
What is your instruction, Mr. Chutia?
The next meeting, my lord.
The court has to be compassionate to hear compassionate appointment applications.
My lord, sometime I be given, my lord, so no, I have lost the file also, my lord. After view.
All right. But Mr. So-and-so, F.A. Laskar, I counsel for the petitioner, Mr. T.C. Chutia, and additional senior government advocate Assam, praise for further 4 weeks time to obtain instruction in the matter. Prayer allowed this.
Yes, my lord, I have got it, my lord. I have got it. I have gone through it. Yes, I have got it, my lord. This is the, my lord, case, my lord. The lordship kindly see, my lord. Lordship dispose of the matter. Because, my lord, see, lordship kindly see page 12. 12, not 12 exactly. It is in minute, page 10, annexure 1. This is the, my lord, this is a state level committee because there is no vacancy. That's why state level committee, lordship kindly see page 12. The executive engineers, so and so, Silsor, placed the above mentioned proposals for recommendation of appointment under compulsory ground. The matter was discussed thoroughly and decided that since there is no post available in the respective office and also in the office of the district as a compulsory quota, executive engineer Silsor, Durban Division, Irrigation Kananpur, Silsor is requested to send all the pending proposal to the administrative department to take up the matter with the departments of the government of Assam to provide for any appointment. That is the clause 15. Taking the provision of clause 15, my lord, that is the, my lord, DLC, my lord, send it to the administrative officer. Also, direct the, my lord, this department,
No, Mr. Chutia, the SLC has considered his case. No.
No, man, that's what it has not gone, man. There is no post in the district level. Man, there is no post for compulsory appointment. That's why the proposals they were this says man, sent to the man, executive engineer, Urban Irrigation Department to send it to the administrative department, commissioner and secretary. Then commissioner and secretary will, as per provision of the provision of clause 15 and 2015 office member they will consider it. Lordship, that.
Where is the standing council irrigation? Not to be seen.
Simple thing, my lord.
Mr. Upadhyay, you are there.
Yes, Lord.
What is your response? You have to provide, executive engineer has to provide, but executive engineer is not even a party here. Have you got the response from the executive engineer?
No, you're not yet. I think they allowed time.
Huh?
I think they allowed time to obtain the instructions.
No, you cut the order, so and so for the petitioner. Mr. TCTK, Learning Government, additional senior government advocate Assam is present on behalf of respond numbers 2 and 4. Miss
DS
DS Nyogi, Land Standing Council Irrigation Department, some praise for and is granted 4 weeks further time to seek instruction and appraise this court as to whether vacancies are available for accommodating the petitioner in the parent department, and if not, in any other department within the district of Kachar. Kachar is the matter of vacancies available in the grade 4 category in the parent department, and if not. Yes, what is your response, Mr.?
My lord, we file a affidavit, my lord, 124/123. So, my lord, if you go by para 6 of our affidavit, my lord, yes, we have, my lord, handloom has forward this to the government, my lord. But thereafter, what happened, my lord? Because of this finance, my lord, OM, that is in annexure 4, my lord. Annexure 4. Umadevi comes in, my lord. That is the problem, my lord. She needs regularization, my lord. How can you regularize her? That is the problem, my lord. Oh,
Why you cannot? Why she cannot be regularized?
my lord, if you go by Umadevi, my lord, for regularization, there has to be a sanction post, number 1. There has to be advertisement, my lord. Yes, she has 10 years continuous, but that was a one-time measure, my lord. But my lord, our OM now, this finance OM, 16 June 2012, that comes in between, my lord. For the finance department has declined, my lord, to regularize her. We have sent it, but because of this.
Who is for the finance department?
My friend Nayak, my lord. They are a party here, my lord.
So we'll have it by the name of finance department reflected in the call list.
Yes.
Heard Mr. Chettiar Learning Council for the petitioner, also heard Mr. R. Dhar Learning Council appearing for the handloom and textile department. Assam will submit that a proposal for regularization of the petitioner sent by the department has been turned down by the finance department. If that be so, let this matter be listed again after 3 weeks by reflecting the name of learned standing council finance department in the corpus. So you may not be aware, there is a matter, item 29.
I informed him.
It will be listed again after 3 weeks. You please seek instruction. Item, yes, that's the order.
Lordship, here in this case, Lordship, we have to file an affidavit, Lordship. After Bihu, any date, Lordship, can fix the matter. And during this time, we will file the affidavit.
Lordship as last chance lordships. All right, heard Mr. R. Sharma, Learned Counsel for the writ petitioner. In this batch of petitions, also heard Mr. J.K. Goswami, learned additional senior government advocate assistant, appearing for the state, who prays for and is granted 2 weeks further time as last chance for filing affidavit. Let these matters be listed again after 3 weeks.
Lordship, in this matter, I need some time, Lordship. Kindly grant me some time to take the instruction, Lordship. They are filing, even they file an IE.
Mr. L. Mohan, learned counsel for the applicant is present. On the request of Mr. R. R. Gogoi, learned standing counsel Forest Department, Assam, this matter stands adjourned for 2 weeks so as to enable him to obtain instruction. List the matter accordingly.
All right, Lordship.
Item 40.
May please, Lordship. Now, last occasion, my lord, response number 6 has been added in the requisition. Notice may be issued to the response number 6.
Notice has been issued to other respondents.
Others, I am preparing, Lordship. Yes.
Will you accept notice for?
Lordship.
Heard Mr. H. R. Amin, learned counsel for the petitioner, also heard Mr. S. S. Roy, learned CGC appearing for respond numbers 1 to 5. Issue notice upon respond number 6, returnable in 4 weeks. Mr. S. S. Roy, learned CGC expects notice for the respond number 6. As such, no formal notice is required to be sent to the said respondent. Mr. Roy to file affidavit, bringing the stand of his client on record within 3 weeks from today.
Obliged.
This is the case of the lady employee of LIC, who is my lord home loan, my lord. Lordship, may first see your lordship's order dated my lord 23/2023. 23/2023. There, my lord, first gave a peculiar order asking me to come to the High Court for an opinion. Your lordship found fault with the language of the order. My lord, passed by the letter given by my lord the LIC. Then my lord, they rejected the prayer thereafter. There is an additional affidavit, which your lordship, additional affidavit dated my lord 23/3/23. Where they withdrew this order, earlier order, and issued this order. Additional affidavit, my lord, has your lordship got it?
Additional affidavit filed in the IA?
I.
No.
Additional affidavit 23/3/23. Is there, my lord? Can I have the file? Hassan?
23, yes, it
Yes.
is there, yes.
That order is, my lord, written like this. This is to inform you that circular dated 9/4/19, which is irrelevant, I will show, and circular dated 3/11/16, which is also not applicable. The competent authority has decided that you will not be possible to issue NOC for SFL loan to you as your case is to be taken unconcluded action initiated case. Because there was a disciplinary proceeding, some penalty was imposed on me. I went to the appellate authority, confirmed now, then I came before this High Court, both the orders were stayed by this High Court, my lord, and the main case is pending. Disciplinary penalty, disciplinary order, one pay cut and recovery of around.
What is the case number? What is the main case number?
Main case number, my lord, WPC number 2822 of
2019.
2822.
This case I filed, my lord, challenging the order of punishment
WPC number 2822 of 2000.
19. This case I filed, my
What
lord,
is the stage in that case?
My-
Readings are complete.
disciplinary proceeding complete.
No.
I was, my lord, although the inquiry officer said that charges were not proved, this,
All right, we'll finish up that case also.
that is pending, that will take some time, man.
On 9th of May, this and that together will.
No, my lord, now, my lord, kindly come to this.
Hmm.
This order, again, my lord, came before. My lord, Learned Singhal just in the other court on 31-3 order, your lordship kindly have a look at 31-3 miss case.
Hmm.
Because my husband also works, we paid for a joint loan. Husband has been given NOC for home loan.
Hmm.
I am not being given, and I am hard pressed to, my lord, deposit money to the builder. That is the problem.
Hmm.
My lord, here, lordship, this is, so I wanted to complete his instruction with respect to application filed by so and so. This court directed NOC for housing loan and apprised the court as to such orders that may be passed by the LIC after revisiting the order dated 23. And after due consideration of applicable and rules. And by relying on this circular,
Yes, Mr. Barbara, you please wait for one more date. I'm tagging the other matter. We'll take it up for final disposal, the other writ petition also.
lordship,
I'm making it clear, it will be the first item in the admission column on 9th of May.
the loan matter will also.
This and that both will finish off.
This is the loan matter, my lord, because they made a reference to this petition. Therefore,
So if this writ petition is allowed, this becomes infructuous. If the other writ petition of your client is allowed,
yes,
this becomes academic exercise.
if it is not allowed,
Then we'll have to mold a relief. That is why,
suppose I am in a position, if it is not allowed,
yes,
then what?
then
Penalty?
we'll have to,
No, then one great pay cut will remain. Recovery of 70,000 remain, that is the punishment.
Hmm.
My terminal benefits are around 60 lakhs, which the day I retire, LIC owes me rupees 60 lakhs and prayer is for 30 lakhs. Home loan, both between husband and wife. That is all lordship will observe.
so we'll take care of
Yes.
that.
That may be.
We'll take care.
My lord,
You can choose between 8th and 9th of May, whichever date you want.
my lord. Yes, lordship, 9th of May.
9th of,
9th of May.
I have filed one affidavit, Melody yesterday. It will be come to the record. Copy also, sir.
Affidavit in which case?
In IA.
All right, you see, the idea of the court is, we'll first see what is there in the other matter. If there is nothing, then why should that case be unnecessarily kept pending?
Right.
If you cannot show any valid ground,
Hello,
it's set
Sumit.
aside. The
Hello.
case will automatically be taken care of. If it is other way around, then we'll see how your interest can be protected.
Right.
And don't release the amount of loan if you give her. 150% of that amount, keep it with you always. It's not a question of she not repaying you. It's a question of your rules not permitting it.
Exactly.
That's it.
This is our.
That's why we look.
We are
into
not against her, but the policy decision is that nobody wants to give because everybody in fair. If we circle office, headquarter office, the policy guidelines, if we violate, then we'll get shockers. May.
No, that's right, but the court order you have to comply
That is
with.
it. That is what we are waiting for. That is why
They
lordship.
are basically banking on one circular of my lord, 494/2019.
So that can be your stand.
That's it.
If the court passes an order, you have to comply.
They
with
will comply, definitely they will.
9419.
That order will pass on 9th.
Lovely.
And Mr. Anything you want to say? Anything you want to add? You want to add anything?
No, they are only banking on a circular, my lord, and so this is not applicable even as we are here. Right
We'll
now.
see. If the other matter cannot be disposed of also, then
Suppose
also.
the writ petition is dismissed, even then I get the loan, man. I have not been dismissed from service.
Absolutely. So I am just posting both the matters together so that they.
For admission hearing.
Yes, as far, yes. Take down, heard Mr. A.C. Barbaran and senior counsel appearing for the applicant, also heard Mr. S. Nath, learned counsel representing the insurance company. After hearing the submissions of both the sides, this court is of the view that the IA is required to be taken up for consideration along with WPC number 2822 of 2019. As such, registry to list the writ petition as first item in the in the column of admission hearing on 9/5/2023.
Right. Right.
May I please, Lordship? Lordship, this is an interlocutory application.
Hmm.
Lordship, impugned order dated 22/7/2022 is annexed here. Lordship may come to page number 11, Lordship. And some oversight and mistake, the petitioner forgot to actually could not file the impugned order in the writ petition, Lordship.
My lord, it's a fresh cause of action, my lord. This will file a.
You
fresh-
tell her she's not aware.
My lord.
You can't challenge an order like this in an IA.
Yes, Lord.
Either you amend your writ petition or withdraw it with liberty to file a fresh.
Yes.
For whatever reason, if you have missed out, you have to do it in a proper manner. Not like this. What do you want to do?
Withdraw it, liberty, Lordship.
You want to withdraw?
Yes, Lordship.
Right. Take down. Miss.
The Angana, the Angana, the Angana.
Is D. Angana and I counsel for the writ petition. The order in WPC number 546 submits that due to oversight, a vital order could not be impugned in the writ petition, as a result of which a defect has crept into the petition, which requires to be rectified. As such, Ms. Angana seeks leave of this court to withdraw the writ petition with liberty to file a plea. Mr. S. Dattal, Learned Standing Council, PNRD Assam, PNRD Department Assam, and Ms. M.D. Bora, Learned Government Advocate Assam, appearing for the respondents, do not have any objection if the prayer is allowed. In view of the above, the writ petition stands disposed of with on withdrawal with liberty as prayed for. And then you will write, in view of the order dated so and so passed in WPC 5477 of 2023, this IA stands disposed of. All right, to file a writ petition, impugn it, make some pleadings to challenge,
Yes, Lordship.
then your
Publish,
case will
Lordship.
move fast. Yes.